Hi everyone, my name is Samidha Hegde. I am an intern at LEXIS and Company. I am a third year law student studying in Ramaya College of Law, Bangalore. And today I am going to be talking about Doctrine of Lis Pendens under Transfer of Property Act 1882. Now, lis pendens means a legal suit which is pending before a competent court for consideration. This doctrine has been derived from the Latin maxim ut pendens nihil innovator, which means that during litigation nothing can be changed. That means the status quo has to be maintained and the property cannot be sold, transferred or tampered with in any way. Now, what is the object of this doctrine? The object of this doctrine is to safeguard the rights of both the parties to the dispute, and this is mentioned under section 52 of the Transfer of Property Act 1882. So section 52 can be in simple words construed as during pendency of the litigation, property cannot be transferred or dealt with, and if so transferred, then the transfer is bound by the decision of the court whether or not he had notice of the proceeding. It means that during the pendency of the proceeding, the property cannot be sold, and if it is sold, let's say A sold the property to C and the dispute was between A and B. Now, after the judgment, the court says that the property belongs to B, then C will have no remedy in court and the property will go to B because C was supposed to be careful before buying the property from A. Now, there are certain conditions to this doctrine as mentioned in under section 52. That is, the suit must be pending before a competent court, and the property must be directly in question in dispute. That is, the dispute cannot be something unrelated to property, and you cannot say that because of doctrine of lis pendens the property cannot be sold. So the property must be directly the subject matter of the dispute, and if a transfer occurs, then it must affect the rights of the parties. The transfer is not allowed during the pendency of the proceedings, but should a transfer occur, then it affects the rights of the parties. For example, if A and B have a dispute over one property and both are claiming that the property belongs to them, and during the pendency of the proceeding, if one party sells the property to some other third party, then it affects the right of the other party. So as per section 52, the property in dispute must be directly subject matter of the dispute, and it should affect the rights of both the parties. And so for how long can the property be withheld and not be sold? That is from the date of application of the before the court for the proceeding and until the court has delivered the judgment, given a decree, and the parties have agreed to the judgment. That is, there is no further appeal to that decision. So that's all. Hope you liked today's video, and I have made 2 other videos previously. Please like, share and subscribe to the channel, and don't forget to subscribe press the notification bell.